A sloth, a donkey, and a curious human. Send a prompt and see what they're doing. One hits record with a question on his mind. Two brothers pick it up, see what they find. Corn takes his time, Herman's got the facts. Back and forth, they never hold back. My weird prompts, come on in, that's where we begin. My weird prompts, glad you're here.
This episode was generated using artificial intelligence. Please verify facts.
My Weird Prompts is a community-driven initiative exploring how AI can fuel curiosity and uncover the fascinating ways our world works. GPU compute for this podcast is generously provided by Modal. Learn more at modal.com.
The lights of the courtroom in Jerusalem are a long way from the cabinet room, but for the last 6 years the distance between them has felt shorter and shorter. We are watching something unprecedented, even by the standards of a country that has seen its share of political drama. Today is March 14th, 2026, and the prompt from Daniel is about the ongoing criminal trial of Benjamin Netanyahu. We are focusing specifically on the intersection of judicial integrity and what many see as a massive, perhaps even dangerous, political distraction.
It is a massive topic, Corn, and one that has essentially defined the Israeli political landscape for nearly a decade. I am Herman Poppleberry, and I have been digging into the mountain of transcripts from the cross-examination in Case 4000 that has been dominating the headlines this month. As we sit here in March of 2026, the trial that started back in 2020 is reaching what feels like a final fever pitch. Netanyahu is finally on the stand, and the stakes for the Israeli legal system are just as high as they are for the Prime Minister himself.
It really is a collision of two worlds, Herman. On one side of the screen, you have the leader of a nation facing existential security threats on multiple fronts, threats that have only intensified in the last year. On the other side, you have that same leader spending his mornings being grilled about boxes of cigars and media coverage from over a decade ago. It feels like a strange, fractured reality. Is he a statesman or a defendant? Can he be both at the same time without the country tearing itself apart?
That tension is exactly what makes this so complex. We should probably lay the groundwork first for everyone listening because these cases have a lot of moving parts, and after 6 years, it is easy to lose the forest for the trees. There are three main pillars to the prosecution's argument, often referred to as cases 1000, 2000, and 4000.
Right, and Case 1000 is the one that usually gets the most headlines because it feels the most personal and, frankly, the most relatable to the average person. It is the gifts affair. The prosecution alleges that Netanyahu and his wife received around 700,000 shekels worth of luxury goods, mostly high-end cigars and pink champagne, from wealthy businessmen like Arnon Milchan and James Packer. The argument is that these were not just gifts between friends, as the defense claims, but were given in exchange for political favors, like helping Milchan with a United States visa or pushing for tax law changes that would benefit him.
And then you have Case 2000, the newspaper affair. This involves alleged negotiations between Netanyahu and Arnon Moses, who is the publisher of the Yedioth Ahronoth newspaper. The claim here is that they discussed a quid pro quo deal where the paper would give Netanyahu more favorable coverage if he helped pass legislation that would weaken a rival newspaper, the Free Daily Israel Hayom. It is a messy look at the backroom deals between media moguls and politicians.
But the big one, the one that the prosecution really hangs its hat on for the bribery charge, is Case 4000. This is the Bezek Wallah affair.
Case 4000 is where the technical details get very dense, but it is also where the legal jeopardy is highest. The prosecution argues that Netanyahu, while serving as both Prime Minister and Communications Minister, granted regulatory favors worth hundreds of millions of shekels to the Bezik telecommunications company. In return, the owner of Bezek, Shaul Elovich, allegedly gave Netanyahu and his family editorial control over the Walla news site, which Bezek owned. This is the first time in Israeli history that positive media coverage has been framed as a bribe in a criminal trial.
And that brings us to the current moment. It is worth noting that while Case 4000 carries the bribery charge, all three cases involve charges of fraud and breach of trust. That specific phrase, fraud and breach of trust, has become the center of a massive legislative battle recently.
You are referring to the bill the governing coalition introduced just 2 months ago in January of 2026. They are trying to effectively repeal those specific statutes, or at least narrow them so they cannot be applied to a sitting prime minister in this way. It has created a constitutional standoff because the trial is happening while the law itself is being debated in the Knesset. It is a race between the verdict and the legislature.
This is where I start to have some real questions about the integrity of the process, Herman. When you look at these charges, especially fraud and breach of trust, they feel incredibly vague. In the United States or many other Western democracies, you generally need a very clear, money in a bag quid pro quo for a criminal conviction of a high-level official. But in Israel, breach of trust is this broad, catch-all category that seems to give prosecutors an enormous amount of discretion to decide what is and is not a crime after the fact. It feels like they are criminalizing the gray areas of politics.
I hear that concern, and it is a major point of debate among legal scholars. The argument from the prosecution side is that the public trust is a tangible asset. If a leader uses their position to create a conflict of interest, even if you cannot prove a direct dollar-for-dollar bribe, they have still harmed the democratic fabric. The Israeli Supreme Court has historically viewed the breach of trust statute as a necessary tool to keep government clean in a system that does not have the same checks and balances as, say, the United States.
But is it actually keeping it clean, or is it just creating a tool for what people call lawfare? If the definition of a crime is so elastic that it depends on a prosecutor's interpretation of a leader's relationship with a businessman, then no leader is safe from a motivated legal department. It feels like the prosecution is trying to criminalize the way politics has been done for decades. If you look at case 1,000, 700,000 shekels over a decade is a lot of cigars, sure. But is it topple the government level of crime? It feels petty compared to the stakes of the nation.
Well, we have to look at the precedent here. Israel has a very consistent history of holding its highest officials accountable, which is actually quite rare globally. We saw Ehud Omer, a former prime minister, go to prison for bribery and breach of trust. We saw Moshe Katsav, a former president, go to prison for much more serious crimes. The Israeli judiciary prides itself on the idea that no one is above the law. From the perspective of the Attorney General's office, if they did not prosecute these cases after the police and the state witnesses recommended them, it would look like they were giving Netanyahu a free pass because of his political power. That would be the ultimate breach of trust.
But there is a massive difference between the Olmert case and this one. Olmert's case involved actual envelopes of cash. That is a clear-cut, black-and-white crime that any citizen understands. In Netanyahu's trial, especially Case 4000, they are arguing that positive media coverage constitutes a bribe. That is a dangerous road to go down. If a politician doing a favor for a media mogul in exchange for better coverage is a crime, then half the politicians in Washington, London, or Paris should be in handcuffs. It feels like the prosecution is stretching the law to fit a specific target because they could not find the smoking gun of actual cash.
The prosecution would counter that it was not just positive coverage, but actual editorial control. We have seen the text messages and emails where Netanyahu's aides, like Nir Hefetz, were allegedly dictating headlines, demanding that certain stories be buried, and even attacking the wives of political rivals on the Walla site. They argue this crossed the line from standard political PR into a corrupt exchange of government regulatory power for personal political gain. They are saying Netanyahu used his power as communications minister to put money in Elevich's pocket, and Elevich paid him back with a propaganda machine.
Even if we accept that it was unseemly, is it criminal? This is what I find so frustrating about the whole situation as we watch this play out in 2026. The trial has been running for 6 years. We have seen hundreds of witnesses, and yet the public is more divided than ever. It suggests to me that the legal system is being asked to solve a political problem. If people do not like how Netanyahu handles the media or his wealthy friends, they should vote him out. Using the courts to try to remove a sitting leader who has been repeatedly re-elected feels like a subversion of the will of the voters. It is essentially an attempt to achieve through the judiciary what the opposition could not achieve at the ballot box.
I think we have to separate the political outcome from the legal process, though. If a crime was committed, the fact that the person is popular or a great statesman does not mean the trial should stop. In fact, you could argue that the more powerful the person, the more important it is that the trial proceeds to show the system cannot be intimidated. But I do agree with you on one point. The length of this trial is a structural failure. 6 years is an eternity in politics. It creates this permanent state of instability where the leader is always looking over his shoulder at a judge rather than forward at the horizon.
And that instability has real-world, life-and-death consequences. We are in a period where Israel is facing massive security challenges. You have the ongoing tensions in the north, the situation in Gaza, and the broader regional threats from Iran. Can a prime minister truly focus on those existential threats when he is spending his mornings in a courtroom being cross-examined about whether he liked a specific headline on the Walla news site in 2015? It seems like a recipe for a national security disaster.
That is the distraction argument, and it is a heavy one. Even the most ardent supporters of the trial have to admit that it places a massive burden on the executive branch. This is where the international pressure comes in. We saw Donald Trump recently weigh in on this, essentially calling the whole trial a witch hunt and pressuring President Isaac Herzog to issue a pardon to end the madness.
Trump's intervention was fascinating because it framed the trial not as a legal matter, but as a matter of global stability. His argument was basically that Netanyahu is too important to the stability of the Middle East to be tied up in these legal proceedings. It was a very pragmatic, almost realist view of the situation. He was basically saying, let the man lead and stop the distraction. It resonated with a lot of people who feel that the legal system is being too rigid at a time when the world is on fire.
But President Herzog's reaction was equally telling. He rejected that pressure and essentially said that the Israeli judicial process must run its course. For Herzog, and for many in the Israeli legal establishment, granting a pardon while the trial is ongoing would be a surrender of sovereignty. It would be saying that political expediency or foreign pressure is more important than the rule of law. It would set a precedent that any future leader could just get a pardon if they have enough powerful friends abroad. It would effectively kill the independence of the Israeli courts.
I understand Herzog's position from an institutional standpoint, but it feels like he is ignoring the reality on the ground. The country is being torn apart by this. You have half the population that sees this as a legitimate legal process, and the other half that sees it as a judicial coup. When the divide is that deep, the rule of law starts to lose its meaning because it is no longer seen as impartial. It is seen as just another weapon in the political arsenal.
That is the danger of the January 2026 bill to repeal the fraud and breach of trust charges. If the coalition passes that law to save their leader from a conviction, it might solve the immediate political problem for Netanyahu. But what does it do to the public's faith in the law? It looks like the players are changing the rules of the game while the game is still being played. It is the definition of a conflict of interest.
But Herman, if the rules were bad to begin with, shouldn't they be changed? If the breach of trust statute is as vague and easily weaponized as critics say, then repealing it is an act of legal reform, not just a political bailout. You can argue that the Knesset is fulfilling its role as the legislative branch by clarifying the law. We talked about this in episode 743, the fine line between legitimate criticism of a system and an attempt to dismantle it. If the law is broken, the legislature is the only body that can fix it.
True, but the timing is what makes it so toxic. If they had changed the law 10 years ago, it would be a policy debate. Changing it now, specifically to affect an ongoing trial of the person who leads the coalition, is a massive ethical hurdle. It is like a defendant in a trial being given the power to rewrite the criminal code. It creates a circularity that is very hard for a democracy to sustain without collapsing into autocracy.
It brings us back to the sitrep method we talked about in episode 553. How do we filter the noise from the signal here? The noise is the constant back and forth about cigars and champagne, and who said what to which publisher. But the signal is a deep structural conflict between the legislative and judicial branches in Israel. The trial is just the battlefield where that conflict is playing out. The real question is, who has the final word in a democracy? The judges or the elected representatives?
I think you are right. This is a stress test for the entire Israeli democratic architecture. It is not just about one man. It is about whether the judiciary can remain independent when it is under sustained attack from the executive, and whether the executive can function when it is under sustained scrutiny from the judiciary. One thing I wanted to bring up, corn, is the specific detail in Case 4000 regarding the Beziq regulatory favors. The defense has been arguing that those regulatory decisions, specifically the merger of Beziq and the satellite provider, yes, were actually recommended by the professional staff at the communications ministry.
That is a classic defense in these kinds of cases. If you can show that the policy had a legitimate basis and was supported by the bureaucracy, it becomes much harder to prove that it was a corrupt favor. It turns the trial into a debate over telecommunications policy, which is incredibly boring for a jury, or in this case, a panel of judges. But it is a very effective legal strategy. If the experts said, do it, how can you prove Netanyahu did it only for the media coverage?
It is effective, but the prosecution has been countering with testimony from state witnesses like Shlomo Filber, the former Director General of the Communications Ministry. Filber testified that Netanyahu gave him a hand-wave instruction to take care of Elevich's interests. The prosecution argues that even if the policy had some merit, the way it was pushed through was corrupt. It is a classic he said, she said, but with thousands of pages of documents and text messages as backup.
This is why the cross-examination happening right now is so critical. Netanyahu is finally getting his chance to answer these claims directly under oath. He has been very forceful, basically arguing that he is the victim of a coordinated campaign by the media, the police, and the prosecution to topple a right-wing government. He is framing his defense not just in legal terms, but in ideological terms. He is saying, they are not coming after me, they are coming after you, the voters.
Which is exactly what his base wants to hear. It reinforces the idea that the trial is an attack on their identity, not just on a politician's conduct. This is why the polling in Israel has remained so static for years. People have picked their sides and very little that happens in the courtroom seems to change their minds. It is a legal process that is failing to provide a sense of closure or resolution for the public.
That might be the biggest tragedy of the whole thing. A trial is supposed to establish the facts and provide a clear outcome that everyone can accept, even if they do not like it. But this trial has become so politicized that it is hard to imagine any verdict being accepted as legitimate by the whole country. If he is convicted, his supporters will call it a coup. If he's acquitted, his detractors will call it a failure of the system.
We should also touch on the international legal context. In episode 710, we talked about the definition of the crime of crimes, and while that was a very different context regarding international law, it highlights how much weight we put on legal definitions. Here, the definition of breach of trust is the pivot point. If it is too broad, it is a tool for tyranny. If it is too narrow, it is a license for corruption. Finding that balance is what the Israeli courts are struggling with right now.
It makes me wonder about the long-term precedent. If this trial ends with a conviction based on media coverage, does that mean every future prime minister has to worry about every interaction they have with a journalist? Does it mean they have to clear every gift, no matter how small, with a team of lawyers? It could lead to a kind of bureaucratic paralysis, where leaders are so afraid of the legal consequences that they stop taking any kind of bold action.
Or it could lead to a much-needed cleanup of the relationship between money, media, and politics in Israel. There is an argument to be made that the culture of gifts and backroom deals with publishers had become so entrenched that it needed a massive shock to the system to change it. Sometimes the rule of law has to be painful to be effective. The question is whether the patient can survive the surgery.
I see that point, but the price is incredibly high. The social cohesion of the country is being shredded. When you have the Prime Minister's supporters calling the prosecutors traitors, and the protesters calling the Prime Minister a criminal, you are losing the shared reality that a democracy needs to function. It is hard to fight external enemies when you are this divided internally.
The role of President Herzog in this has been very difficult. He is trying to be the unifier, but by refusing the pardon, he has become a target for the right. By not speaking out more forcefully against the trial, he is seen as complicit by some on the left. It is a lonely position to be in. The failure of the pardon request was a signal that the institutional gears are still turning, regardless of the political heat.
And then you have the Trump factor. His public pressure on Herzog was seen by many as a breach of diplomatic norms. But from Trump's perspective, he was just being his usual disruptive self, trying to cut through what he sees as a deep state mess to help an ally. It created a very awkward situation for the Israeli government, which generally wants to stay on Trump's good side, but cannot appear to be taking orders from a foreign leader on a domestic legal matter. It was a clash of two different styles of leadership, the institutionalist versus the disruptor.
It was a fascinating moment of friction. The Israeli government actually had to push back and say that their legal system is independent. It was a reminder that even for the closest of allies, there are lines that cannot be crossed without undermining the very sovereignty of the state.
So, as we look at where things stand today, Netanyahu is on the stand. The cross-examination is ongoing, and the Knesset is debating a law that could change everything. It feels like we are approaching a climax, but we have been saying that for years.
The timeline is the big unknown. Even after the testimony is finished, it will take months for the judges to write their verdict. And whatever the verdict is, it will almost certainly be appealed to the Supreme Court. We could easily be looking at another 2 or 3 years before there is a final resolution.
That is wild. By then, we will be in 2029. Netanyahu will have been under the cloud of this trial for nearly a decade. At some point, you have to ask if the process itself has become the punishment. Regardless of whether he is guilty or innocent, the trial has fundamentally altered the course of his leadership and the history of the country.
It has. And it has forced Israel to confront questions about its own identity that it might have preferred to avoid. Is it a country governed by its elected representatives or by its legal elite? Can those two groups find a way to coexist, or is this a fight to the finish?
I think the takeaway for me is that the trial is a mirror. If you believe the system is corrupt, you see the trial as proof. If you believe the leader is being persecuted, you see the trial as proof. It is not changing minds, it is just hardening them. The real test will be what happens the day after the verdict. Can the country accept the result and move on? Or will it just be the start of a new, even more intense conflict?
That is the big question. One practical takeaway for listeners who are following this is to watch the Supreme Court's reaction to the coalition's repeal bill. If that bill passes and the Supreme Court strikes it down, that will be the moment of truth. That is when the constitutional crisis moves from the theoretical to the actual.
It is also worth keeping an eye on the specific testimony regarding Case 4000. That is the legal heart of the matter. If the prosecution can make the bribery charge stick, the whole political landscape changes. If they cannot, and it is just the breach of trust charges left, the argument for a pardon or a political solution becomes much stronger.
I agree. We should also acknowledge the role of the state witnesses. Their credibility is being shredded by the defense, but they are the ones who provide the inside look at how the Netanyahu circle operated. Whether you believe them or not, their testimony has provided a fascinating, if somewhat grubby, look at the intersection of power and media.
It is definitely not the most inspiring look at how a government works. But then again, maybe that is the point. Maybe the trial is exposing things that were always there, just hidden under the surface. It is a deep, painful, and very public examination of the Israeli political soul.
I think that is a fair assessment. It is a stress test for democracy, and the results are still pending.
Well, it is certainly not boring. I think we have covered the main angles here, Herman. It is a topic that we will probably be coming back to as that verdict gets closer.
I am sure we will. There is always a new development or a new witness that shifts the perspective.
Before we wrap up, I want to say thanks to our producer, Hilbert Flumingtop, for keeping the gears turning behind the scenes.
And a big thanks to Modal for providing the GPU credits that power the AI systems we use to research and produce this show.
This has been my Weird Prompts. If you are enjoying our deep dives into these complex topics, a quick review on your podcast app really helps us reach more people who are looking for this kind of analysis.
You can also find our full archive and all the ways to subscribe at myweirdprompts.com. We have over 1,100 episodes there if you want to dig into our past discussions on legal frameworks and Israeli politics.
We will be back soon with another prompt. Until then, stay curious.
Bye, everyone.
This episode was generated using Gemini Flash 3. Text-to-speech engine was Chatterbox.
Thanks for listening to our show, my keep